Welcome to the Assembly Committee on Education. Madam Secretary, will you please call the roll?
Assemblywoman Duran.
Here.
Assemblyman Flores.
Present.
Assemblywoman Gorlow.
Here.
Assemblywoman Hanson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman Krasner.
Here.
Assemblywoman Marzola.
Here.
Assemblyman MacArthur.
Here.
Assemblywoman Miller.
Here.
Assemblywoman Nguyen. Assemblywoman Tolles.
Here.
Assemblywoman Torres.
Here.
Chair Bilbray Axelrod.
Here. And please mark Assemblywoman Nguyen absent excused. She will be joining us. She just alerted me that she will be a little late, and that is just 'tis the season right now. So we do have a quorum. For those viewing the meeting online or on our YouTube channel, welcome. And to those participating for these hearings on video or via phone, welcome. Before we begin, I'd like to make a few housekeeping announcements. If you have not done so already, please be sure to mute your microphone when you're not speaking and minimize background noise. Committee members, please make sure to keep your cameras on for the duration of the meeting to make sure a quorum is present. We do expect courtesy and respect in this committee. We don't always agree on policy, but we need to be respectful to each other and the legislative process. A reminder that meeting materials can be accessed on the committee's webpage on Nellis. And for those of you who are watching online in this virtual world, we do have several screens going on. So if you see members looking away, they are likely looking at another screen or many different things, notebooks to look at the meeting material for the meeting today. So we have three bill hearings this afternoon. For the bill hearings this afternoon, I have allocated equal time for testimony, support, opposition, and neutral. Each person providing testimony will be allowed a maximum of 2 minutes. Staff will time each speaker to ensure everyone is given an equal opportunity to speak. Speakers are urged to avoid repetition of comments by previous speakers. So if they said exactly what you wanted to say, you can just say ditto to that. Since we do have three bills, we will have to limit testimony to 30 minutes. If you wish to testify and you have not done so already, please register online through the link provided on the agenda for the meeting. Upon successful registration, you will receive a telephone number, meeting ID, and instructions for joining the meeting. So that we have an accurate record and count, we ask you not to share this information, but instead encourage others to register online to participate. You may also submit public comment in writing. If you do not wish to testify but still want to register your interest in a bill, you can do that online. And at any time, members of the committee may request testifiers to submit documentation to support their testimony. I am now going to open the hearing on AB 67. Superintendent Ebert, please begin when you are ready.
Thank you. Good afternoon, Chair Bilbray Axelrod, Vice Chair Miller, and members of the Committee on Education. This is State Superintendent of Public Instruction, Joan Ebert, for the record, presenting Assembly Bill 67, also known as our Discipline Clarity by the Department. Assembly Bill 168 from the 2019 session chartered an ambitious vision for restorative practices in Nevada. This vision aligns with the Nevada Department of Education values of equity, access to quality, and inclusivity. And we are proud to continue to lead this work for our state. This bill was pre-filed by the governor on behalf of the Department of Education to clarify the requirements of AB 168. But this bill was truly filed on behalf of our students who benefit from safe and respectful learning environments that provide restorative justice supports. The clarifying language will also support districts and schools in continuing to implement AB 168. The proposed changes to law are intended to, first, create definitions for suspension, expulsion, and permanent expulsion, which are in sections 15, 12, 13 respectively, and make conforming changes to disaggregate data by suspension, expulsion, and permanent expulsion in sections 1 through 3. The proposed changes create unique discipline policies for pupils with disabilities in charter school applications per section 4, as well as conforming changes for charter schools and schools for profoundly gifted students in sections 5 through 8. Section 9 makes conforming changes to eligibility for independent study. And as we move forward, AB 67 also clarifies that a designee of a school board can be used in place of the school board in all instances of student-level discipline. Such hearings and proceedings are to be closed to the public, which is in the best interest of the student. Existing laws associated with hearings in a school district and can be found in section 23. AB 67 also creates consistency for references to students with a disability in sections 4, 22, and 23. Section 22 clarifies that only suspensions of 3 or more days can be used to determine whether or not a student has a record of habitual disciplinary problems. Section 23 provides language related to the age of a student in the simplest terms and clarifies that a student removed for more than 1 semester must seek educational services. The department submitted a technical amendment to provide additional clarification for school district discipline hearings and proceedings as follows. We've proposed edits to section 6, 8, 23, 24 in that proceedings, like hearings, would be closed to the public and that the school board may appoint a designee. These edits create consistency with all other revisions in the original draft of AB 67 that permit boards of trustees to authorize designees. This is in the best interest of students whose disciplinary matters should not be open to the public. The technical amendment also proposes a change to section 15 to remove a gap in the definitions for suspension and expulsion. The amendment proposes suspension to mean the disciplinary removal of a pupil from a school in which they are currently enrolled for up to 1 semester. This updates state policy in accordance with the Federal Individuals with Disabilities Education Act, or IDEA. Finally, related to a pupil's age, Section 24 responds to stakeholder requests for clarity regarding permanent expulsion of students younger than 11 years of age. Our proposed amendment in Section 24 aligns with the originally drafted Section 23, subsection 9, through which a school may request an exemption from a district board of trustees that would allow a school to permanently expel a student younger than 11 only in extraordinary circumstances. This, with the last session of AB 168 and this bill of AB 67, I want to personally express my gratitude to all of the superintendents and every educator that has worked over the last 18 months to refine and clarify many of the aspects that were in the original bill. A lot of discussion and time. The team here, led by Will Jensen, who is our Director of Inclusive Education. I also have our Director of the Office of Safe and Respectful Learning Environments, Christy McGill. And I also am joined by Amber Reed and Dr. Jonathan Moore, who is our amazing deputies. And I cannot forget, we also have our other colleague in the South, Felicia Gonzalez. So at this time, I want to thank you all for hearing this bill, listening to and seeing our conceptual amendments, and we are open to questions.
Thank you, Superintendent Ebert. And members, are there any questions on AB 67? I am not. Oh, Yeah, I waited too long. Assemblywoman Hardy.
Thank you, Chair Bilbray Axelrod. My only question, when section 24 talking about being allowed to permanently expel someone under the age of 11, do you have like an example of what an extraordinary circumstance would be?
Thank you for the question. So in those instances, we're talking about weapons, weapon use, drugs, and other things in that realm.
Thank you.
Thank you. And I believe it looks like Assemblywoman Marzola asked, Assemblywoman Hardy asked Assemblywoman Marzola's question. So is that correct? Okay. Okay, so any other questions from committee members? Looking at the Zoom. Okay. If not, then we are going to move on to testimony. So we will start in support. Please remember to clearly state and spell your name and limit your testimony to 2 minutes. BPS, can you please call out the first caller in support?
Not a problem, Chair. To testify in support on AB 67, please press *9 now to take your place in the queue. Caller with the last 3 digits of 202, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Thank you, Madam Chair and members of the committee. My name is Paige Barnes, Paigebarnes. I'm with Crowley and Ferrata Public Affairs. Today I'm representing the Nevada Association of School Boards. We are in support of AB 67. We appreciate the work of the department that they've done over the interim and their collaboration with all school districts. Thanks so much.
Thank you so much. Can we have the next caller in support?
Caller with the last 3 digits of 411, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Thank you, Madam Chair. For the record, this is Lindsay Anderson, LINDSAYANDERSON, on behalf of the Washoe County School District. I'd like to thank Superintendent Ebert and her team for working with our team extensively over the interim to clarify some of this language. In this case, ambiguity in the law creates inconsistency across schools, and so these definitions are very important. Our team will take an opportunity to look over this amendment, but it appears that particularly the designee language is very helpful to make sure that school districts can respond to these instances in a timely manner without having to wait for boards of trustees to get together. So we are in support and we are grateful to see this legislation coming forward. Thank you, Madam Chair.
Thank you, Ms. Anderson. Any other callers in support?
Caller with the last 3 digits of 692, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good afternoon, Madam Chair and members of the committee. For the record, my name is Mary Przynski, MaryPierczynski, representing the Nevada Association of School Superintendents, which consists of all 17 superintendents in the state. And we very much appreciate the work of the Nevada Department of Education Superintendent Ebert and her staff, and especially Sarah Nix, who we worked with quite a bit on this particular bill. We appreciate the definitions, as I think Ms. Anderson noted, and also we appreciate the fact that the school boards now can appoint a designee when it comes to these hearings on suspensions or expulsions. That's very important to us. So we're in support and thank everyone very much for working with us and hearing our concerns. Thank you.
Thank you very much for the call. Is there anyone else in support?
Caller with the last three digits of 577, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good afternoon, Chris Bailey, DALY, Nevada State Education Association, the voice of Nevada educators for over 120 years. NSEA believes in the principles of restorative justice, which proactively build healthy relationships and a sense of community to prevent and address conflict and wrongdoing. We are in support of AB 67 to make important clarifications to Nevada's system of restorative justice. The issue of student discipline continues to be one of the more vexing ones for all educators. During the 2017 session, NSEA worked to improve Nevada's old system of progressive student discipline. Then last session, this was replaced with a restorative justice model. Unfortunately, school districts were not provided with the guidance and resources necessary to successfully implement, and student and educator safety has been compromised. Every day, educators make students feel welcome in the classroom and at school sites. Many utilize learning circles, conflict resolution, mediation to deal with challenges and resolve conflict. However, this work is often independent of broader school culture. It is necessary for there to be proactive district and school-wide plans to implement restorative practice that is seamlessly integrated into the classroom, curriculum, and culture of the school. This also means providing needed trainings to foster an environment where restorative justice systems can be successful. Restorative practices should extend throughout the school site and should engage all staff to create and maintain a safe physical space, a supportive school climate, an engaging academic environment, and healthy relationships between students, peers, and staff. Meanwhile, NSEA always takes a strong stance for the safety of educators. We look forward to continuing our work with the Department of Education on implementation of successful restorative justice practices. Thank you.
Thank you, Mr. Daly. Anyone else in support?
To the callers who have just joined to testify in support on AB 67, please press star 9 now to take your place in the queue. Once again, for anyone who just joined, to testify in support on AB 67, please press star 9 now to take your place in the queue. Chair, at this time, we have no more callers in the queue to testify in support on AB 67.
Thank you, BPS. We will close testimony in support, and I will open testimony in opposition of AB 67.
To testify in opposition on AB 67, please press star 9 now to take your place in the queue. Once again, to testify in opposition on AB 67, please press star 9 now to take your place in the queue. Chair, at this time, there is no one in queue to testify in opposition on AB 67.
Thank you. I will close opposition testimony. Is there anyone wishing to testify in neutral on AB 67?
To testify in neutral on AB 67, please press star 9 now to take your place in the queue. Caller with the last three digits of 023, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
My name is Brenda Pearson, BRENDA PEARSON. Hello and thank you, Chairwoman Bilbray Axelrod and committee members. My name is Dr. Brenda Pearson, and I am here representing the Clark County Education Association. CCA is testifying in neutral on Assembly Bill 67. I would like to thank this committee for bringing the bill forth. This bill provides much needed clarity to ensure our restorative practices are implemented. The addition of definitions for expulsion, permanent expulsion, and suspension will pair very well with the additional requirements prescribed in AB 194 and will help to standardize the approach to restorative justice across all 17 school districts. However, the designation to include pupils with disabilities in student disciplinary procedures may end up negatively impacting students more than intended. This session, the Judiciary Committees have heard many bills discussing the competency of a minor and whether that competency should be measured similarly to an adult. Much like that quandary, we must ask whether a child with a physical or intellectual disability should be treated similarly to any other child when we are already trying to change our approach to prevent recidivism. A successful implementation of AB 67, AB 194, and preceding student discipline bills must be built upon a strong foundation of restorative practices. Today, there is little such foundation in Clark County, so movement from traditional behavior management to restorative practices must encompass robust supports, including ongoing training and coaching. In short, a move to restorative practices requires both a change in the behavior of the educator and the student. CCA appreciates the intent of this bill, but we ask that the sponsors look at the significant publication materials on juvenile justice to ensure that these changes are something that will be standardized, unbiased, and easy for our educators to adopt and students to understand. Most importantly, we ask this committee to consider AB 194 and the need of the appeal process to ensure fairness and due process. Thank you again to the committee for hearing this bill, and we look forward to continuing the restorative justice conversation as it pertains to education.
Thank you very much for the call. Any other callers in neutral?
To testify in neutral on AB 67, please press star 9 now to take your place in the queue. Chair, at this time, we have no one in queue to testify in neutral on AB 67.
Thank you, broadcast. I will ask Superintendent Ebert. A question did come up during testimony. It is actually in section 23 in the existing language, and I will turn it over to Assemblywoman Marzola to ask the specific question that we would just like some clarification.
And thank you for the presentation. My question relates to page 25 of the actual bill, and it's lines 37 through 41. Can you hear me?
You are breaking up a little bit, Assemblywoman, but it's on in.
Can you hear me now?
Section 23, page 25, lines 37 through 41.
Correct. So my question is, as I read it, this section doesn't prohibit a pupil from having in his or her possession a knife or firearm with the approval of the principal of the school. So my question is, because that shocked me, when would it be okay for a student to have a knife or gun in his or her possession?
Superintendent Ebert, for the record, thank you for the question. And what I would add to, in lines 37, also going through 41, a principal may grant such approval only in accordance with the policies or regulations adopted by the Board of Trustees of that specific school district. So each school district then would have their own determination of when that would be appropriate. And I guess I'll pause right there.
Are you able to give me some examples when it would be appropriate for a student to have a knife or a gun in his or her possession?
Thank you. So we have ROTC programs across the state in schools. And so that would be one example that I would offer.
And I'm not familiar with the ROTC program. I know of it, but I haven't been in it. Do they bring the guns with them to school? Are the guns in a locker at school somewhere?
Thank you for the question, Superintendent Ebert, for the record. So with ROTC, in those specific instances, there actually are competitions that the students do participate in with a gun at that point in time. In that instance, that would be appropriate. They are doing it part of the program that they are participating in with the school district's permission.
Can I have a follow-up, Chair?
Sure.
And as far as a knife, would you be able to give me an example of that one?
Awesome. Thank you, Superintendent Ebert, for the record. So in those instances, we're talking, a specific example would be in a culinary course. We have several successful programs across the state, as well as agriculture. Those programs are just two examples that I would offer you as appropriate for having a knife on a campus.
Thank you. Thank you, Chair.
Thank you for that clarification. Any other closing remarks that you would like to make, Superintendent Ebert?
Thank you for the opportunity, Chair. Again, I just can't emphasize enough since the initial signing of the bill, we have worked very hard together to make this what's best for children, and I believe we have achieved that. Thank you.
Thank you so much for being here. With that, I will close the hearing on AB 67, and now I am going to open the hearing on AB 194. This bill revises provisions governing the suspension and expulsion of pupils. Assemblywoman Torres, please begin when you're ready.
Thank you, Chair. Good afternoon. Thank you, Chair Bilbray, Axelrod, Vice Chair Miller, and members of the Committee on Education. For the record, I am Assemblywoman Selena Torres, and I proudly represent Assembly District 3 in Las Vegas, Nevada. And this afternoon, I will be presenting AB 194, which revises provisions governing suspension and expulsion. Before I begin, I would like to provide a brief roadmap of today's presentation. First, I'll provide some background information on this bill and why I'm bringing it forward today. Then I'll pass the presentation to Kelly Venci Gonzalez, Team Chief of the Education Advocacy Program with Legal Aid from Southern Nevada, who will walk the committee through this bill. Throughout today's presentation, I'll be referring to the legislation as modified by the conceptual amendment. I want to note that the conceptual amendment has been emailed to my colleagues here on the Assembly Committee on Education and has already been posted on Nellis. I want to thank all the stakeholders who have reached out and collaborated with me over the last few months. We've had thoughtful conversations and have been able to find common ground. And this is represented with the work and this conceptual amendment. So I'll begin by giving some background information. The Brown v. Board of Education states that education is perhaps the most important function of state and local governments. And it is with this mindset that I opened the dialogue on AB 194. The genesis of this legislation was watching students and their families struggle to appeal with the suspensions and expulsions of their students. In the summer of 2020, thanks to the help of the amazing staff here at LCB, it became clear that the appeals process for Nevada school districts varied an incredible amount. If a student violates their school's code of conduct, the appeals process from one school district to another is nearly unrecognizable. This seemed unjust. This body knows that students of color are disproportionately suspended and expelled from schools. This is not unique to Nevada. Nonetheless, African-American students are significantly more likely to be suspended or expelled. This legislation does not resolve this issue, but works to ensure that students that are suspended and expelled from school are afforded due process and that schools are required to plan for how they will implement restorative justice and train their school staff and faculty. Nonetheless, schools have the responsibility to provide students with this due process. Education is a right afforded to Nevadans. The U.S. Supreme Court case Goss v. Lopez indicates that the right to a free and public education cannot be withdrawn on grounds of misconduct absent fundamentally fair procedures to determine whether the misconduct had occurred. Nevada students do not shed their constitutional rights at the doors of our schools. Education is a property and a liberty interest to our students. School suspensions and expulsions have a lasting impact on our kids. It impacts their education, their likelihood of getting accepted in college, and may even impact them if they end up in the criminal justice system. Both Goss v. Lopez and Brown v. Board of Education established that students have due process under the 14th Amendment, no matter how arbitrary the incident. This legislative body had the responsibility to ensure that this due process is clear in statute and in regulation. This legislation, as amended, does not seek to outline what due process will look like in Nevada schools. Rather, this legislation seeks to require the Office of Safe and Respectful Learning Environments within the Nevada Department of Education to release guidance on what this appeals process would look like and what that timeline should look like. At this time, I will introduce Ms. Kelly Venci Gonzalez from the Legal Aid from Southern Nevada, who will walk the committee through this bill.
Thank you, Assemblywoman Torres. My name is Kelly Venci Gonzalez, Team Chief of the Education Advocacy Program. Honorable members of this committee, thank you so much for taking time to listen to this bill today. Section 1 builds off the restorative justice practices that were implemented in the last session to ensure teachers have the tools they need to effectively implement restorative practices in the classroom. Listening to stakeholders and various constituents, there's a recognition that additional support is needed so teachers can do the hard work of restorative justice, and this bill aims to make that support happen. Section 2 and 3 require that when a child and family is exercising their right to appeal, that child is still able to receive the education in the least restrictive environment possible. That might mean the option of behavior school. It might mean an online platform. This is very important because kids can often stay out of school for weeks while the discipline process is making its way through the various levels of appeal. And we don't want kids to miss school just because they're facing discipline. We want them to stay current in their studies and stay up, because what happens is if they miss a month or 6 weeks, they are that much further behind and it only exacerbates the problems. That's what we have found in our practice. Section 5 requires school districts to adopt a policy for appealing suspensions and expulsions for students, and that the process must be explained to parents so that they have information they need to decide if appealing is appropriate in their case. So that's just making the appeals process consistent across the state and very clear to parents so that they can make choices that are best for their families. It also clarifies that if a family chooses to appeal, the punishment cannot be increased as a result. We have seen in some cases where the threat of review may lead to harsher punishment has scared families out of exercising their right to appeal, even if they feel that they have merit or grounds for appeal. Section 5, subsection 2 and 3 requires that the appeal process or policy be posted on the school district's website so that families have access to this information, and clarifies the appeal hearings are closed to the public. Section 5, subsection 4, sections 7 and 8 added in by amendment that the Office for a Safe and Respectful Learning Environment at the Nevada Department of Education will establish a timeline by regulation for students' appeal process and oversee the regulatory process of the bill. As a result, the timeline originally proposed in this bill has been stricken. And at that, I would just welcome any questions from the committee at this time, and thank you for listening to us.
And Assemblywoman, is that the end of your presentation, or do you stand for questions?
Yes, thank you, Chair. We stand for questions.
Thank you. Committee members, do we have questions? I see Assemblywoman Hanson is raising her hand. Assemblywoman Tolles is raising her hand. That's it for now. We'll start with you, Assemblywoman Hanson.
Thank you, Chair, and good afternoon. Thank you for the opportunity. So when we were going through the sections and we were in section 3, you mentioned the appeal process to be consistent across the state. I was just curious, and I'm sorry, maybe Assemblywoman Torres, you might have given an example. I had to go off the camera and for a moment. Could you give us some examples of maybe what we've seen happen in some of the inconsistencies in the state on this process?
Yes, thank you for the question. Give me one moment. So over the summer, I did pull up some research and requested that I get some information on what that looked like. Unfortunately, some of our school districts didn't get back information, didn't have an appeals process for short-term suspension or long-term suspension. The majority of our districts actually did not have an appeals process for short-term suspension. As indicated throughout the presentation, we do have a responsibility to provide due process regardless of the length of the suspension or how arbitrary the issue is. Some have an appeals process that, allows for this to, with the principal's, like at the principal's discretion. So it just looks so different in every single county here in Nevada. And some counties didn't really get back to us either. So I think it's just really imperative that we as a legislative body create some kind of consistency so that there is that it just makes more sense for Nevada students. And, quite honestly, when this conversation began, we were looking to put this into statute. And as the conversation kind of evolved, we recognized that this was an area where it would make most sense for these stakeholders to come to the table and have this conversation with the Nevada Department of Education, who I truly believe, is going to understand the needs of our students and be able to work on a process that makes sense for us.
Thank you for that. I appreciate it.
Thank you, Assemblywoman. Next, we will go to Assemblywoman Tolles.
Yes, thank you, Chair, and thank you, Assemblywoman, for bringing this bill forward. I definitely agree with the value of it and the need for it. And I think I just have a clarifying question about the amendment on the timelines, because I did read Section 5 originally before seeing the amendment, and I thought, how would that work practically to have the Board of Trustees have to act when they maybe between meetings and they're not, full-time around. And then I know that in Section 5, we've deleted the timelines and we're adding, so that helped because that now no longer is, I think, relevant if I'm understanding the amendment correctly, but we're adding a new subsection that the department shall, in consultation with the Office of Safe and Respectful Learning Environments, establish a timeline by which the actions required by subsection 1 must occur. So in layman's terms, who's the one who's actually implementing the timelines? Is it the district or is it the Board of Trustees? Because I guess my question is how could the Board of Trustees meet those deadlines if they only meet, on certain days out of the month?
Thank you, Assemblywoman, through the chair to the Assemblywoman, Assemblywoman Torres, for the record. I think that's that's a good point, right? But I think ultimately I trust that the Nevada Department of Education isn't going to implement timelines that our school boards wouldn't be able to meet. I trust that, the Department of Education is going to work to ensure that whatever timelines are issued would be reasonable, but also allow for students to receive due process. And I think, realistically, like having some type of timeline is a part of that due process. And I think that's timelines for families as well as timelines for schools, right? So one of the issues that we see, and I know Ms. Venji could speak more to this, would be that like families are considering an appeals for a suspension or expulsion, and sometimes they're taking 3 weeks. That's 3 weeks when their student is out of school. And so I think having timelines for families, having the timelines for the individuals that are administrating it makes sense to ensure that we can really get our kids back in school or continue to receive as much of an education as our children deserve.
And this is Kelly Venci Gonzalez. Just to further that, what we've seen in practice is that, and especially we're talking about vulnerable kids. I represent kids in foster care. And they could be sitting out for a month while it makes its way through the process. And the reasons for delays can come in so many different areas. It can be the school doesn't submit the paperwork properly, so it gets kicked back to the school and the school refiles it. Sometimes the school forgets to file it to ESD. That's the first level of appeal. So there's a lot of steps along the way where paperwork can delay. And meanwhile, that child is sitting out of school, maybe getting some level of instruction, an hour, a week or so, or maybe just sitting out of school and not getting any instruction. And for our kids in foster care, for our vulnerable kids, it affects placement. Foster parents can't keep kids that are home if they work, if they have other kids, so it can disrupt placement. For our kids at Child Haven, it can hinder placement because foster parents aren't as willing to maybe take a child that shows behavior problems to the extent that they're out of school. So this way, I think keeping timelines and keeping everybody on track to reach that final determination of whatever is the appropriate discipline would be really important for families and the school district. It helps everyone out. And most importantly, it helps the child because they are in school, they're keeping current. Even if they have behavioral problems, they still need to be making progress towards their grades and their academics. Thank you.
Madam.
Thank you for that. Well, and let me just say something for the record. I'm wondering if the amendment to AB 67 might also allow for a designee. And I know we don't have legal, but I don't know if Ms. Robusto, if you had a thought on that.
Hi, Chair. Christy Robusto, Senior Policy Analyst, LCB. I believe we still have Superintendent Ebert on the record who spoke about the allowance of a designee, which was in the document that they shared that said for Section 24 with NRS 392-467, except as otherwise provided in subsections, the Board of Trustees of a school district or its designee may authorize the suspension, expulsion, or permanent expulsion. I'm not sure if Superintendent Ebert would like to clarify if that would also be addressed with regard to an appeals process, if she has any insights on that.
I believe she is still on.
I am, Madam Chair, if you'd like me to.
Oh, I apologize. Yes, thank you very much.
Great. For the record, Superintendent Ebert, we would love to work with the bill sponsor to make sure that the language is aligned between AB 67 and AB 194.
Thank you. I'm sorry, I was looking for your name, Superintendent, not the Department of Education. I apologize.
Madam Chair.
Ms. did you have a follow-up?
I did, if I may. Okay. So thank you. And I had no questions about the value of setting up the timeline. I want to make sure that that was clear. I definitely see that value. My question was more, and I think we just answered that. Is it possible to look at maybe it's better to have the Department of Education direct the district to act within that timeline versus the Board of Trustees? But I believe that we just answered that question with the designee. So thank you for that discussion. And I did have one more question about Section 11, if I may, or sorry, Section 10.
Go ahead.
Thank you so much. And I just wanted to revisit in Section 10, subsection 5, the removal of the section that says the department shall adopt regulations necessary to carry out the provisions of this section. And maybe I'm missing it elsewhere, but I just, I'm wondering if that's going to impact the ability to essentially carry out or enact those regulations. So as I read it, the department, in consultation with the Office of Safe and Respectful Learning, will provide that guidance, but is it put in somewhere else where they'll be able to enact it?
Thank you.
Assemblywoman Torres, for the record, through the chair to Assemblywoman Tolles, I think that's a question better asked for legal. That's a conforming change to the legislation. So I would need to consult with legal. I'm not sure if Mr. Robusto has any thoughts on that, but that was communicated to me as a conforming change.
Christy Robusto, Policy Analyst, LCB. I will confirm with legal and work with Assemblywoman Torres on that. Thank you.
Thank you, Ms. Robusto. I know we have a couple more questions from members and we still have another bill to hear. So let's move on to Assemblywoman Miller.
Hi, thank you, Chair. My question is, and I'm going to say this, preface it because of the risk of it being taken out of context, but often, or the intent of suspensions and expulsions should not be punishment, but it's more should be removing that student or the behavior from a situation to maintain a safe and respectful learning environment for all. That should be the intention. And so with that, we also, as we're, and I'm just considering extreme cases of suspensions and expulsions. And also with our restorative justice model that we're still adapting and evolving into, the restorative justice is for not just the person who committed certain acts, but also for the victim. And so with this, I was just wondering if in the appeals process, has it ever been considered to have as part of the appeals process, maybe the parents and or students who were victimized as well, if they have a voice or an opportunity to be part of this appeals process?
Thank you for the question, Vice Chair Miller, through the chair to the vice chair for, I appreciate the question, but I think this legislation and the intent of this legislation is pretty clear in allowing for the Nevada Department of Education to create the guidelines of what that should look like. And so I think that it would be up to the amazing team over at the Office for Safe and Respectful Learning Environment to determine what that appeals process would look like. I don't think that I myself as a legislator, I'm the best individual to outline exactly what that appeals process should look like. And I also know that due to the legislative process, it would be very hard for us to come back and change it. I do think that by changing it through regulation and empowering the Nevada Department of Education to create the guidelines of what that should look like, we allow for these conversations to be had. And I think that that is a viable part of the conversation. But I don't want to get into the nitty-gritty of what that would look like at this specific moment, because I think that that's what the office should ultimately determine.
Okay, thank you. I appreciate that, because I do appreciate the consistency across the board for everyone. Thank you. Thank you, Chair.
And next we have Assemblyman Flores. Sorry about that.
Thank you, Madam Chair, and thank you, Assemblywoman Torres, for your presentation. So I have two questions, and the first maybe is a little bit of a broader question, but I know you walked through some of the Supreme Court case law to talk about where we get some of our guiding principles as to what's protected and what isn't when we talk about a school. Specifically our kids in our schools. So do you have a position, or have you had an opportunity to discuss with the stakeholders? Are we not complying then with Supreme Court case law presently? It's important for us to understand that and the urgency of a bill like this. If what we're reading in the Supreme Court case law is saying we're supposed to be abiding by X, Y, and Z, and we're not presently doing that, are we out of compliance then?
Thank you for the question, Assemblyman Flores, through the chair to the Assemblyman. I'm not an attorney and I'm not an education attorney, so I don't want to get into the nitty gritty of whether or not we're meeting, we're following this law in each school district. But the reality is that the appeals process that we have is in some cases non-existent or very difficult for individuals to follow. I think that it's likely that we'll hear testimony from individuals today that can attest to the challenges that they received while appealing a school suspension or expulsion. And I think it's important that we have this dialogue and conversation. Given that the appeals process, that due process is a right for students, regardless of the length of the suspension, how long it is, the expulsion, for what the issue is. I think it's important that we have this dialogue and that we as a state are ensuring that we are providing our students with the due process that they deserve and that is protected.
Understood. Madam Chair, if I could have a quick follow-up for a different topic.
Go ahead.
Thank you, Madam Chair. And thank you for that, Assemblywoman. And obviously, we all have to work collectively to ensure that we're doing that. And that's why I bring that up. I also during the presentation with your co-presenter, one of the things that was brought up that just struck me as very odd, and I just wanted to dive a little bit deeper into that conversation, was a scenario where a student's about to be expelled, and then because the parents and or the child decided to appeal, that the consequences could be more severe. And that to me struck me as incredibly odd. So somebody trying to appeal resulted with them being threatened that the consequences would be much more severe. If we could talk a little bit more about that, I'm assuming anecdotally that came through some families. I'm just curious to know what happened in those scenarios.
This is Kelly Venci Gonzalez, Education Team Chief. I can answer that question. And in my capacity as an attorney representing students and families in discipline proceedings, I've seen firsthand the school district say, well, here's your next level of appeal, but just so you know, it could be, they could implement a harsher punishment. So you want to take that into consideration about whether you're going to appeal or not. For my clients, that especially, I remember one client, this child had autism, did not have an IEP or a 504, good grades, good student, said some things that were taken out of context, and it resulted in his expulsion from school. The family felt very strongly that this child was kind of the subject of bullying, of targeted and kind of set up by other students. But since he was alleged to have said the words, that it was a threat, it kind of took on its own life. And so, a discipline was leveled out, and both the child and the family were like, we didn't say this, we don't believe this happened this way, but I don't want my child to be expelled for the whole semester. I'll take 6 weeks at a behavior school because I don't want to risk it being that much worse. If I go up that other layer of discipline and it's worse, I've done nothing for my child. So it's something that our families really take seriously when they are, considering how to best advocate for their child. And I wish that was an isolated incident, but it hasn't. It's happened over the course of me representing families in discipline proceedings. That is sort of hung out there as kind of a consequence for families, and they want to do what's right for their kids. Even if their kids have made mistakes, they still want to do what's right for them.
Yeah, well, that just sounds crazy to me. So I appreciate that, but that's just crazy. I don't got any other word for that. Thank you.
Thank you, Assemblyman, and thank you for the answer, Ms. Gonzalez. Do I have any other questions from the committee? Otherwise, okay, I have two. I have Assemblyman MacArthur and Assemblywoman Duran. So go ahead, Assemblyman MacArthur.
Thank you. I'm sorry I couldn't get on the chat for some reason. Quick question. On page 9, number 4, says a pupil who is suspended or expelled is entitled to receive an appropriate education. How was that done?
Well, currently, if I may answer, this is Kelly Venci Gonzalez. It can be AIA, which is done after school for a certain amount of time. That's how it traditionally is done, or they can get work packets. I think in working with the school district here, they've come up with a wonderful solution, which will, for kids that are accused of significant offenses, maybe offenses involving violence, that they would have the option to go to behavior school during the pendency of the proceedings. Or they could, one of the things of COVID is we've learned how to do online education. And so that would be another opportunity. And the goal is to keep kids in school in some fashion, even if they're accused of violence, they still need to be marching towards school. There are a lot of studies that when kids are out of school, they get into trouble. When they're not supervised, they get into trouble. So we believe that the behavior school option for some of our kids would be a good option that would keep them in school during these proceedings while they're worked through the appeals process.
Okay, I just didn't know what a behavioral school was.
I apologize. Down south here, a behavior school is another campus. They're highly structured, they're smaller, they're schools away from other campuses. They get a lot of attention, a lot of individual attention. So that's one option. There are STAR-on programs here down south, which is sort of a behavior school on campus, but sort of segregated from the other kids. So there's different options available. But if a child is, say, expelled for bringing a gun to campus or getting in a fight or assault on a teacher, what may happen is they would go to behavior school. And so for kids that are working through discipline proceedings of some of those most serious offenses, they would have that option to continue to go to school on behavior school while their case was going through the appeals process.
Okay, thank you, Madam Chair.
Thank you, Assemblyman. And Assemblywoman Duran.
Thank you, Madam Chair. Going back on what my colleague, Assemblyman Flores was talking about, somebody, getting a harsher punishment for filing an appeal. I mean, isn't discipline supposed to be corrective and not all punitive? And what example is that sending to our students that threats are okay, that you can't stand up and try to fight for what you believe in? If
Thank you, Assemblywoman Duran, through the chair to Assemblywoman Duran.
Go directly.
Thank you. I appreciate it. It's always such a mouthful to go through the chair. So I think that's exactly why I brought this legislation, right? Like, I recognize how challenging it was for students sitting in my classroom that were struggling through the appeals process. If they and their family were comfortable doing so. And I think that the hope really is that the school districts can get the guidance from the Office of Safe and Respectful Learning Environment, and that can be in accordance with the restorative justice principles that I know that our Department of Ed has worked so hard to implement. And I'm hoping that, that appeals process that is, side by side with restorative justice. And, I did over the last couple months, I've met with the Department of Ed and we've had conversations about this legislation. And I think that this was actually one way that we found would help allow for this process to really be restorative and to be part of that cutting edge, so that if, as educational research expands to ensure that the regulations that are put into place with its appeals process for school suspension and expulsions make sense. And if something's not working, that it can be quickly addressed, right? If that timeline makes no sense in that circumstance, that we can then address that timeline and give it and expand it as necessary. So that's exactly the genesis of this legislation. And I'm excited to see this come to fruition so that we can ensure that all of our students have due process and that it's not just punitive punishment, but truly restorative.
Follow-up or just a comment? So I just dealing with that, I think that, people should be held accountable for not following the process, and hopefully this bill will correct that as well. Thank you.
Thank you. And I think we are going to go ahead and move on to testimony, just because we do have another bill and afternoon committees as well. So with that, we will go to testimony in support of AB 194. BPS, do we have callers in support?
To testify in support on AB 194, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 017. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Thank you. My name is Sylvia Lazos, Lazos. I am a parent of 2 CCSD teenagers. I'm also an education advocate and have worked closely with the Latinx and Nevada Immigrant Coalition on various bills. I unfortunately have a son who got himself into some discipline problems at Coronado High School, and I experienced firsthand this situation where a principal kind of makes it up as he goes in terms of discipline. My son was told that he was going to be expelled from Coronado for a second offense. And when I received that news, my reaction was, number one, you never told me about this. This is not published on your webpage. And this is clearly disproportionate versus the offense that he committed. Yes, he was a bad boy, but he should not be summarily expelled. I wrote to the principal. He didn't even read my email. We went through the appeal process. It took about 4 to 5 weeks, and in my opinion, took all of my legal skills and my partner's legal skills to go through that process. We were explicitly counseled to drop the appeal at Coronado, even though we explained over and over how unfair we viewed this. And it wasn't until the 4th week when we got to a neutral panel that we were able to get the situation dismissed. I don't know how a normal parent navigates this. I'm telling you, literally, it took 2 skilled lawyers to get justice for my child. And when that's the situation, there is a total failure of the system. I will just add that I have raised this repeatedly with CCSD, and they don't seem to care about this issue. So that's when the Nevada legislature should step in. When a school district doesn't care about fairness, our legislature should. Thank you very much.
Thank you so much for that call. Next caller in support.
Caller with the last 3 digits of 831. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good afternoon, Madam Chair and members of the committee. For the record, my name is Cecia Alvarado, CECIA, ALBARADO. And I am the Nevada State Director for Mi Familia Vota. Mi Familia Vota is a national civic engagement organization that unites Latino, immigrants, and allied communities to promote social and economic justice through citizenship workshops, voter registration, and voter participation. Today, I'm submitting this testimony in support of AB 194 on behalf of Mi Familia Vota. According to the American Psychological Association, suspensions increase the chance of a student leaving school prior to graduation from 16% to 32%. Another study found that students who were suspended or expelled were 29% more likely to drop out at some point during their high school career. Loss of learning time is a serious consequence of school discipline. Black and Hispanic or Latinx students are more likely, on average, to be suspended and expelled from school. AB 194 will require transparency from school districts so the communities are aware of progress made or not made on the school to prison pipeline. Mi Familia Vota respectfully urges this committee to support AB 195 and thanks Assemblywoman Selena Torres for sponsoring this bill. Thank you.
Next caller in support.
Caller with the last 3 digits of 080. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Hi, Jim Hoffman, Hoffman, representing Nevada Attorneys for Criminal Justice. NACJ supports AB 194. The school-to-prison pipeline is a serious problem, and part of why it exists is that there's not always consistent rules and standards for how schools deal with student misconduct. AB 194 helps to address this by creating a more consistent appeals process. As any parent knows, consistency is very important in child discipline. AB 194 advances that goal, so NACJ supports it. Thank you.
Thank you for the call. Next caller in support.
Caller with the last 3 digits of 927. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Hello, and thank you, Committee Chairwoman Bilberry Axelrod and committee members. My name is Hava Ahmed, Hawah, and I am here representing the Clark County Education Association. Prior to accepting my job at CCEA, I worked at a rural district court where I was able to understand the juvenile justice system that in many cases began with minor offenses that included school suspension and expulsion. In my time since I began working for CCEA, it has become abundantly clear that the juvenile justice approach varies from county to county and school district to school district, and that an appeal process is needed if we want to truly utilize restorative justice practices and prevent recidivism and escalation of offenses. In many ways, we must approach juvenile justice with compassion and understanding for the children and families. That is why CCEA supports AB 194. AB 194 presents an opportunity for a standardized appeal process with notice to families, amended to allow for processes to be defined by regulation that allows for flexibility in the evolution of restorative justice in Nevada. It is important to note that though CCEA supports this bill, we feel that a necessary component has been missing from our change to restorative practices, and that is training. Our teachers currently feel that the implementation or lack thereof of restorative justice practices is so varied that it fails to get to the root cause of the issue to provide healing and coping mechanisms for children. Instead, many of our processes focus on the aftermath of negative conduct and highlight punishment and confinement. Additionally, the lack of accountability that has accompanied previous bills has prevented our educators from buying into the idea of restorative practices. AB 194 is a game changer. The new accountability measures will help to ensure that data is collected so that every suspension and expulsion is analyzed to better understand and highlight the disparities in the current scheme and to ensure that we can address why we have racial and socioeconomic disparities to prevent any exacerbation of offenses. Overall, this bill provides a much-needed step in our path towards juvenile justice reform. We look forward to continuing our work with Assemblywoman Torres to make this bill a reality. Thank you.
Thank you very much for the call. Next caller in support.
Caller with the last three digits of 455. Please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Chair Bilberry Axelrod, members of the Education Committee. My name is Gil Lopez, GIL-LOPEZ with the Charter School Association of Nevada. We are here in support of Assembly Bill 194. Things we can do to keep children in the classrooms. We're in total support. We want to thank the Assemblywoman Torres for her work around restorative justice. Thank you, Chair.
Thank you so much for your call. Any other calls in support?
Caller with the last three digits of 023. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Hello, and thank you, Committee Chairwoman Bilberry Axelrod and committee members. My name is Dr. Brenda, B-R-E-N-D-A, Pearson, P-E-A-R-S-O-N, and I am here representing the Clark County Education Association. CCEA supports Assembly Bill 194. Overall, this bill provides a much-needed due process for student discipline in Nevada schools. The appeal process, through guidance by the Office of Safe and Respectful School Learning Environment, establish consistency and transparency. CCA expressly supports the submission of an annual report of accountability delineating the discipline of pupils. But we would be remiss if we did not stress the importance of utilizing this data to improve practices across our state. The collection of data must inform actions that will lead to the reduction of racial disparities. This data is a tool to inform our evolving practices and must be used as such. However, given the amendment to allow for the creation of regulation of timelines, we believe that regulation may be used to determine the best practices for use of this data. This bill serves as an impactful continuation of our move towards restorative practices, but we must also stress a continued focus on building a strong foundational knowledge of restorative practices across our schools in Clark County. Thank you again to the committee for hearing this bill. We look forward to continuing our work with Assemblywoman Torres on strengthening restorative practices within our schools.
Thank you very much. Any other callers in support?
For any who have just joined, to testify in support on Assembly Bill 194, please press *9 now to take your place in the queue. Once again, if you wish to testify in support on AB 194, please press *9 now to take your place in the queue. Caller with the last three digits of 149, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good afternoon. My name is Annette Dawson Owens, A-N-N-E-T-T-E, Dawson, D-A-W-S-O-N-O-W-E-N-S. I serve as the School Readiness Policy Director for the Children's Advocacy Alliance. Thank you, Chairwoman Bilbray Axelrod, Assemblywoman Torres, and the committee. We support AB 194 in creating a safe, respectful learning environment and a culture that implements restorative justice practices while revising the suspension and expulsion procedures, ensuring clear due process and consistent practices. We know these restorative justice practices transform perspectives, structures, and students, the community as a whole, while creating a culture that supports the development of our students. We know the importance of all students continuing to be educated. We believe in keeping track of data related to the suspensions and expulsions, analyzing such, and with an eye on disproportionality. We know these investments help students stay in school and receive supports they need for their continued success. Thank you for your noble efforts on behalf of all of our students.
Thank you so much for the call. BPS, are there any other callers in support?
Chair, at this time, there are no more callers to testify in support on Assembly Bill 194.
Thank you very much. We will close testimony in support and open testimony in opposition of AB 194. BPS?
To testify in opposition on Assembly Bill 194, please press *9 now to take your place in the queue. To testify in support on Assembly Bill to testify in opposition on Assembly Bill 194, please press *9 now to take your place in the queue. To testify in opposition on AB 194, please press *9 now to take your place in the queue. Chair, the line is open and working. However, we have no one to testify in opposition on AB 194 in the queue.
Thank you. Is there anyone in the queue wishing to testify in neutral?
To testify in neutral on AB 194, please press *9 now to take your place in the queue. Caller with the last 3 digits of 411, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Thank you, Madam Chair. For the record, this is Lindsay Anderson, LINDSAYANDERSON, on behalf of the Washoe County School District. I just really wanted to get on the record today thanking Assemblywoman Torres for working with our school district so extensively. We had many meetings about this. In Washoe County School District, all but a handful of our suspensions are short-term or in-school suspensions, 3 days or less. We certainly share the sentiment of wanting kids in school, but in some small number of cases, there are safety concerns and student and staff safety takes precedent. Parents are given a form at the time of suspension with some options for an appeal, and never would a student penalty be worse after the appeal process in the Washoe County School District. So we appreciate the chance to work with the Department of Ed to make sure that our process aligns with certainly the law and the intent of this legislation, but giving us a little bit more flexibility through the conceptual amendment is very welcome news. So thank you to the sponsor for her work on this. Thank you, Madam Chair.
Thank you very much. Any other callers in neutral?
Caller with the last 3 digits of 967, please press *6 to unmute. Caller with the last 3 digits of 967, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Thank you, Chair Bilbray Axelrod and the committee members for your consideration today. For the record, my name is Bob DeRuse, BOBDERUSE. I'm the director of ACE Charter High School. ACE High School is a Washoe County School District sponsored charter school. We are a small 200-student, 9th through 12th grade CTE high school with a focus on industry-level learning experiences in construction, manufacturing, and transportation trades for our students. At this time, we are testifying in neutral, changing from opposed with the presentation of the conceptual amendment presented with AB 67. We had initial concerns with the burden that would be placed on our governing board related to the hearing requirement described in Section 5 of AB 194. Our governing board is heavily involved and engaged with our school staff in developing and guiding policy as it relates to student discipline. We are reviewing the conceptual amendment presented earlier in AB 67 as it relates to the designee for the board and the overall impact on AB 194. We look forward to determine the effects of the proposed changes it has on AB 194 related to student discipline. Thank you for your consideration of my testimony today.
Thank you very much. Any other callers in neutral?
Caller with the last three digits of 202, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Thank you, Madam Chair and members of the committee. My name is Paige Barnes, P-A-I-G-E-B-A-R-N-E-S. I'm with Crowley and Fraudo Public Affairs, here representing the Nevada Association of School Boards. We are in neutral on AB 194. We'd like to thank Assemblywoman Torres for working with our partners in the school districts on the amendment. We are looking forward to collaborating with the department on regulations. I would just like to note that all school districts are handling suspensions differently, and in whatever regulations we establish, we would like to maintain some of that local controls for our districts and our boards to manage that process. Thank you so much for your time.
Thank you for the call. Any other callers in neutral?
Caller with the last three digits of 080, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good afternoon, Madam Chair and members of the Education Committee. My name is Leonardo Benavides, Leonardo-Benavides, with the Clark County School District, testifying today in neutral. We have worked with Assemblywoman Torres and the Legal Aid Center over the past few months to ensure students are given due process based on the questions today. We want to make it clear that we are always willing to work with students and their families as they go through this difficult process. Eric Gant, Executive Director of our Education Services Division for Alternative Services, has worked to ensure that this bill helps to minimize the loss of any face-to-face instruction for our students and made himself available on the Zoom line today to answer any questions from the committee in regards to the process through CCSD. Also in regards to the proposed conceptual amendments, with allowing CCSD and NDE to draft the regulations and provide guidance which allows for best practices in each school district. And as the regulations are promulgated, we will continue to work with our partners like the Legal Aid Center in order to reduce the loss of instruction for our students. Finally, I want to thank Assemblywoman Torres for working with us this last few months on this bill to address any initial concerns from the school district side. Thank you for your time.
Thank you very much. Are there any more callers in neutral on AB 194?
Testify in neutral on AB 194. Please press *9 now to take your place in the queue. Chair, the line is open and working. However, there are no more callers to testify in neutral on AB 194 at this time.
Thank you, BPS. Assemblywoman Torres, did you have any closing comments?
Thank you, Chair. And I will keep my final remarks brief. I really would just want to begin by thanking the different stakeholders that have been working with me on this piece of legislation, specifically Ms. Venci Gonzalez from Legal Aid, Mr. Eric Gant, who actually made himself available during the entirety of the Zoom call, and we didn't get to speak with him today, but he has been an excellent ally in ensuring that we're providing our students with due process. So thank you to those stakeholders, and I look forward to continuing to work with the diverse stakeholders on this issue so that we can pass policy that will ensure that all Nevada students have due process in the school suspension and appeals process.
Thank you, Assemblywoman. And with that, I will close the hearing on AB 194. I did want to point out that we have been joined by Assemblywoman Nguyen. I know you came in during testimony when we were on audio only. So if Madam Secretary, if you could please mark Assemblywoman Nguyen as present. I'm now going to open the hearing on Assembly Bill 195. This bill revises provisions relating to pupils who are English learners. Assemblywoman Torres, please begin when you're ready.
Thank you, Chair. Good afternoon to the Education Committee. Thank you, Chair Bilbray Axelrod, Vice Chair Miller, and members of the Committee on Education. For the record, I am Assemblywoman Selena Torres, and I represent Assembly District 3 in Las Vegas, Nevada. And this afternoon, I will be presenting AB 195, which creates the English Language Learner Bill of Rights. Before I begin, I would like to provide a brief roadmap of today's presentation. First, I will provide some background information on this legislation. And second, I will walk the committee through the sections of this bill. Throughout today's presentation, I will be referring to the legislation as it is modified by the conceptual amendment. I want the committee to know that this amendment comes from the thoughtful conversations that I've had with representatives from the various school districts here in Nevada. I'll begin with background information on this legislation, and throughout this presentation, I will be using several different acronyms that apply to this bill and our English language learners. I'll do my best to explain each of the terms that as we work through the legislation, but during questioning, I'm more than happy to explain any of those terms as necessary. EL or ELL is an acronym that refers to English language learners. ELL students are students that are learning English. ELL students in Nevada speak many languages: Spanish, Tagalog, Chinese, French, etc. And many of them are born here in the United States. ELL students can thrive when they are given the appropriate supports. This legislation is intended to help instructional leaders and policy makers alike make informed policy decisions while simultaneously implementing the mechanisms to inform ELL students and their parents and guardians about the rights that they already have. Based on the concerns raised throughout the day, I just want to be abundantly clear that this legislation does not give ELL students additional rights. Rather, this legislation requires that the rights that English language learner students and their families have is enumerated so that they are aware of the rights that they have. ELL students make up 14.1% of the student population and consistently lag behind in proficiency tests. Nonetheless, there's very little data aggregated about their performance. This data is necessary for instructional leaders and policymakers alike to implement modifications to the curriculum. I'll next walk through the sections of the legislation. Chair Bilbray Axelrod, I submitted an amendment to this bill, and I'll be referring to the amendment as we work through this piece of legislation. So yes. I'll begin with section 2 of this legislation, subsection 1 and 2. It requires that the Board of Trustees determines the number of students that are immigrants, refugees, long-term English learners, and English learners. Additionally, this bill requires that the district aggregate the data for ELL students who are in career tech programs, magnet schools, AP courses or advanced placement, international baccalaureate or IB courses, dual credit courses, and extracurricular programs to the extent possible. Section 2, subsection 3, as amended, requires that the Board of Trustees of each school district determines the number of teachers employed that have an endorsement in bilingual ed or teaching English as a second language, and so that this information is then disaggregated by the grade levels that those teachers teach. This will allow for school districts and policymakers and administrators to truly understand how many of their teachers have the certification to provide our ELL students with the top tier instruction that each student deserves. Additionally, section 2, subsection 3, as amended, requires for local education agencies to report on the number of teachers per school that are trained in the LEA's adopted language development program. A lot of our school districts throughout the state have adopted their own language development program. And I know that we have an ELL administrator on this call as well if there's more specific questions about that, but this will allow for us to see how many of those teachers have been trained in that program, and really for our Board of Trustees, our Nevada Department of Ed, and for the legislative body to review that data. This section also requires that this information is submitted to the Department of Education and disseminated to the legislature. Section 2, subsection 6 defines the term long-term English learner, LTEL, is another way that they're referred, and I might refer to them throughout the presentation. A long-term English learner is a learner who has been, as a learner who has been in the United States for 3 consecutive years. This obviously would be applicable in a circumstance where perhaps a student was born here in the United States, grew up here in the United States, left and lived in a different country for several years, and then comes back that student has not been in the United States for 3 consecutive years. And so they're not they're a newcomer. They're not a long-term EL student, even if they attended school 6 years ago here in the United States. Section 3 of this legislation enumerates the rights of an English learner and the rights of the parent guardian of an ELL student. While these rights are presently available to students, the education community knows that oftentimes students and their families do not know or understand their rights. These rights include the right to a free and public education, regardless of their immigration status or native language, equal access to programming, and the right to be evaluated annually. Additionally, parents and guardians have the right to register their student without disclosing their immigration status. They have the right to have an interpreter for significant interactions with their school districts to the extent practicable, and information about the progress of their pupil. Section 3, subsection 3, as amended, requires that the schools provide ELL students with copies of these rights upon annual registration. Upon review of the amendment submitted to this committee, I realized that the addition in section 4 should most likely be added to section 3, although I'll leave that decision to our legal team that I'm sure will know exactly where that should be. As a conceptual amendment states, the Department of Education shall provide translations of the rights described to the primary languages of the households within each school district, including English, Spanish, and Tagalog. These rights will empower students and their families to be involved in their school community and empower families in our community. When parents and guardians play an active role in their child's education, students perform. Section 4 of this legislation requires that the Board of Trustees reports annually on the use of Title III funds to allow for policymakers to understand how the money designated for Nevada English learners is being spent. This report will also be posted on the internet to ensure that Nevadans can understand the use of those funds. This will be helpful to policymakers like ourselves. Section 5 authorizes the Department of Ed to adopt the regulations necessary for this legislation. Section 6 of this legislation requires that schools identify the primary language of a pupil upon registration annually to ensure that students are properly identified as ELL students. Presently, students are identified as ELL students when they complete the home language survey, which is upon their initial registration in a school district. Many families do not initially admit to speaking a different language for fear of this making their child have a less equitable education. Some families fear that this might cause information to be flagged to immigration authorities or worry that their child is going to be put into a remedial program. As families grow more comfortable with their child's school, they're more likely to reveal this information. And so this allows for that information to be asked annually to ensure that that family is maybe comfortable with sharing that information, that child can be properly put in that program. As amended, Section 6, subsection 2, sub G, provides that a pupil who is an ELL student remains placed in the EL program until they reach language proficiency as determined by the state's assessment. Additionally, you will note in the amendment that there is an amended section. The amendment makes a modification to the current NRS 388.157 by requiring that the Read by Grade 3 assessments is a criterion referenced assessment. To understand this assessment, I'll provide 2 different definitions of different types of assessments. There's norm referenced assessments and criterion referenced assessments. A norm referenced assessment measures a student in relation to other students that took the assessment. This is when students are ranked by percentile and measured in comparison to how their peers perform. I know that there's several parents on this committee, so that might be when your child receives an assessment that says they're in the 97th percentile or the 57th percentile. That would be a norm referenced assessment. A criterion referenced assessment assesses the student's knowledge and skills against where their performance should be. This does not measure them against their peers. For the purpose of assessing student reading in elementary school, these assessments should be criterion referenced as educators are attempting to understand the student's skills, specifically literacy. Currently, some schools are using criterion referenced assessments and others are using norm referenced assessments to assess elementary reading literacy. The issue is that norm reference assessments is that the information compares the students to one another instead of actually tracking their literacy skills or comparing them to their classmates. So some students have to win and others have to lose in that type of assessment. When they get to 3rd grade, we monitor student literacy data using the SBAC, which is the state assessment, and that assessment is a criterion referenced assessment. Norm reference assessments don't allow for us to truly measure the literacy abilities of our students. They are designed to discriminate among students and allow comparisons. Educators can better use criteria and reference assessments to determine whether students have mastered specific content. This supports educators in determining student literacy. At this time, I now stand open to any questions that this committee may have regarding AB 195.
Committee members, do we have questions? Okay, I'm not seeing any questions. I know we have quite a few people on the phone, so I will move to testimony in support of AB 195.
Thank you, Chair. To testify in support on Assembly Bill 195, please press *9 now to take your place in the queue.
Para testificar en apoyo.
I will point out that we do have a translator on. I believe the first caller sounds like they do speak English. So, but after this, we will have our translator saying the same thing. Olivia, if you want to say that in Spanish.
Sí, tenemos aquí una traductora para decir exactamente lo que se está diciendo para las personas en apoyo, oposición o neutralidad al proyecto de ley AB 195. Okay.
Gracias. First caller, please go ahead.
No problem, Chair. Caller with the last 3 digits of 831, please press *6 now to unmute. Once again, caller with the last 3 digits, 831. There we go.
La
Please
persona que
fully
llama
state.
con los números 831, por favor, indique su nombre y deletréelo.
Hello, good afternoon, members of the committee. My name is Cecia Alvarado, CECIA-ALVARADO. I am the Nevada State Director for Mi Familia Vota, and I'm calling once again in support of AB 195. Approximately 587,000 foreign-born individuals reside in the state of Nevada, and accounting for 20% of our population. A large share compared to immigrants in the United States, which overall is 14%. With a relatively large population of immigrants, it follows that a student population with one or more foreign-born parents, which is about 42% in our state. And overall, 48% of those are low-income students that come from households with one or more foreign-born parents. Nevada set 2 long-term goals in respect to English language proficiency. The first is that 90% of ELL or English learning students will meet the 6-year maximum timeline to proficiency by 2022, but only 25% of them achieved that in 2016. The second is that 80% of ELL students will make adequate annual growth towards proficiency by 2022, which only 40% of them did so in 2016, which is a reflection of the need for comprehensive support for students and their parents. ELL parents and students have been facing challenges way before the pandemic. Mi Familia Vota worked with a large population of the community that requires ELL resources and access. And even though we are happy to help our community, we believe that it's time for our school district to
Chair, this broadcast, the caller has been disconnected, it looks like on their end. I will go to the next caller.
Thank you.
Caller with the last three digits, 017. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
My name is.
I think we're okay.
Good afternoon. My name is Sylvia Lazos, L-A-Z as in zebra, O-S. I am with the Nevada Immigrant Coalition, and the Nevada Immigrant Coalition has made AB 195 one of its priority bills. I want to spend the time addressing what I will call 5 myths regarding ELLs. I have submitted testimony that provides a lot of statistics on ELLs, which you can read and have a good snore about it. But let me just address some of the myths that may be landing in your email inbox. First of all, ELLs are not illegals. 10 years ago, CCSD did a survey and found that 85% of ELLs are U.S. born. Those who are not U.S. born will likely qualify very soon for citizenship, as they would be deemed to be dreamers. So ELL are part of our citizenship community. Myth number 2, by giving ELL education opportunity, we take away from the opportunities for the general education student. This is a myth in that good teaching practices for ELLs translate to good teaching practices for all students. In particular, the approach that is taken with respect to ELLs is very helpful to students from poverty and students who may have a limited vocabulary because of their ethnic or cultural background. So it is not true that providing ELLs with education opportunities that they are deserving through law is a zero-sum game. Number 3, ELL is a made-up status. No, the ELL status was made up by the Supreme Court of the United States in a case called Lau versus Nichols, in which the San Francisco district simply ignored Chinese students, put them in the back of the room, made no attempt to teach them. Under American civil rights laws, that is a denial of equal opportunity, and that's how ELL status came to be. And that is that every unit, every school district has a legal obligation to provide all students, including ELLs, an education opportunity. Myth number 4, I think it's number 4, ELL means brown, means Latino. That is false. The ELL population is multi-ethnic and multiracial. 66% of APIAs in Nevada are immigrants. 40% of Latinx are immigrants, and 10% of Blacks are immigrants. So the ELL population is very varied and multi-ethnic. In sum, giving ELL parents the right of advocacy, the knowledge to advocate, is not a zero-sum game, but is additive. It benefits every single stakeholder, every single student demographic group. And we should be encouraging every parent to understand their rights and be the best advocate that they can be for their particular student. Thank you very much for the opportunity.
Thank you for the call. And I just wanted to point out to the folks on the line, we do have a translator. So after BPS says the 3 digits, we will have Olivia then say the last 3 digits in Spanish. So even if you go ahead and hit the numbers to unmute, you could wait for her to finish that. And if you are a caller in Spanish, we will translate for the committee. So go ahead, BPS and Olivia.
Caller with the last 3 digits of 987. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Hello, and thank you, Committee Chair Bill Bray, Axelrod, and committee members. My name is Marie Nices, M-A-R-I-E-N-E-I-S-E-S-S, and I am the president of the Clark County Education Association. The Clark County Education Association represents more than 18,000 licensed professionals in the Clark County School District. We are the largest independent teachers union in the country and the state of Nevada. We engage in bipartisan advocacy for advancing public education in Nevada. During my 28 years of employment with CCSD, I worked at 3 Title I schools with predominantly English learner students. I know firsthand how getting a quality education impacts an EL student because I was an EL student when I started kindergarten. Spanish was my first language, and having access to quality instruction and effective educators helped me learn English rather quickly and excel academically. This is why I am strongly in support of AB 195. Last school year, nearly 53,000 English learners attended Clark County schools. Each of these students deserves equal access to quality education. AB 195 establishes rights for both the EL parent and the students and details specific data to be collected by school districts. It is with this data that Nevada can learn about the success and struggles of our EL population. Data must drive Nevada's steps towards equity and access for English learners. As our state moves towards implementation of SB 543, we believe AB 195 would also add a layer of accountability that enables legislators and lawmakers to review our English learners' academic engagement and progress. Thank you.
Thank you for the call. And just to confirm again, Olivia, after BPS says the last 3 digits, if you would just say the last 3 digits in Spanish, in case they are a Spanish speaker.
All right.
Go ahead, BPS.
Caller with the last 3 digits of 091. Please press star 6 to unmute.
La persona que llama con 091, por favor, es su turno. Presione estrella 9.
You will have 2 minutes. Please state and spell your name for the record, and you may begin.
Tendrá
Buenas tardes, good afternoon. Buenas tardes, good afternoon. My name is Felicia Ortiz, spelled Felicia, last name Ortiz. I am the president of the State Board of Education, coming to you today on behalf of myself in support of SB 195. I'm coming to support it for a couple of reasons, specifically the latest amendment, section number 2, for the number of teachers that hold bilingual or English language acquisition endorsements. We just got off a phone call with Superintendent Jara here in Clark County. We're working on starting a bilingual education program, and one of the key things we need to know is how many teachers we have that are endorsed to teach our courses. And that is not currently data that we have at our fingertips, so that's a huge need. Second, I come from a policy perspective, in that from an equity perspective, competency-based exams are more equitable and are not comparing students against one another, are actually testing what students know. So I strongly support that piece of the amendment. And third, I come to you from a business perspective. Our community depends on visitors from around the globe, and helping our scholars embrace their assets of being bilingual will in turn make them more marketable to our local employers. I believe that it's imperative that we provide all of the resources that they need to support their emerging bilingual status and hopefully get them to the point where they earn our seal of biliteracy as part of their diploma when they graduate from our schools. Thank you so much for your time.
Thank you. Next caller.
Caller with the last 3 digits of 982. Please press star 6 now to unmute. Please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Llamador con 982, número 982. Presione el estrella 6 y es su turno.
Madam Chair and members of the committee, my name is Lisa Guzman. That's Lisa Guzman. I am here representing the Nevada State Education Association. I am the Assistant Executive Director of NSEA and an English language educator. I am not here representing the Clark County School District as a trustee. The Nevada State Education Association has been the voice of Nevada educators for over 120 years. NSEA's Reach for the Stars Foundation and our Instruction and Professional Development Department provide educators across the state support in all areas of education. We support English as a second language instructors and bilingual educators with the pursuit of national board certification. We provide micro-credentials to renew the knowledge of educators with English language acquisition and professional development. NSEA supports AB 195 to establish rights for English learners and their families to ensure they have access to highly qualified education. Educators who are both bilingual or English as second language certified advocate for their students and their rights. Research on language learners has proven it takes between 3 to 5 years to acquire English. NSEA appreciates the classification of language learners in this bill. ELL bilingual educators also spend countless hours trying to find ways to ensure that parents and students know their rights to the education system. Too many times, parents are afraid to come to the school to engage in the education process of their child is pursuing. AB 195 will ensure English learners and their parents know their rights. Educators also know we are losing fellow educators with the pedagogy and educators teaching the acquisition of students. Will help happening and within to staff. It also will help inform school trust the data-driven decision-making process. Thank you.
Next caller in support.
Caller with the last 3 digits of 494. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Llamador con el número 494, es su turno y tiene 2 minutos para iniciar. Puede comenzar.
Hi, my name is Kate Lawhorn. It's K-A-T-E-L-A-W-H-O-R-N, and I taught for 7 years in Nevada. Most of my students were English learners. I'm calling today to voice my support for AB 195. Specifically, I would like to address the conceptual amendment of requiring assessments for by grade 3 to be criterion referenced rather than norm referenced. Criterion referenced assessments measure what students can do. Each student is measured in relation to a standard, performance level, or learning goal. Student scores are not based on how their peers performed. These results give teachers actionable data so they can understand how each student is conceptualizing the standards, allowing them to plainly instruct, target specific gaps. Criterion reference assessments are the most culturally responsive method for EL students because they truly measure what students are and are not able to do. Norm reference assessments, on the other hand, measure students in relation to how well they did in comparison to a group of peers. Norm reference norm groups are a national sample of students in each grade level. They do not measure proficiency or mastery, just relative proficiency compared to peers. These assessments do not give teachers the insight they need to make instructional decisions. Most importantly, these assessments measure English learners against native English speakers, causing the test results to present bias. Starting in 3rd grade, students are measured using criterion referenced assessments. Currently, students in earlier grades use norm referenced assessments. The testing instrument should be consistent. Changing the measurement protocol is confusing for students and their families. As a teacher, there's nothing more stressful than testing students when the measurements did not present an accurate picture of what skills and knowledge students possessed or needed. Please support this amendment and this bill for criterion referenced assessments for read by grade 3 measurements. Thank you.
Thank you for the call. Next caller in support.
Caller with the last 3 digits of 927. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Llamador con el número 927, es su turno de hablar. Indique su nombre completo para el acta y deletrelo.
Hello and thank you, Chairwoman Shannon Bilberry, Axelrod, and committee members. My name is Hava Ahmed, a CCEA, and I am reading testimony for Angie Joy. My name is Angie Joy, ANGIE JOYE, and I'm a second grade teacher at Ann Lynch Elementary. I strongly support AB 195, the English Learners Bill of Rights, because many English learners do not receive equal or adequate support in their education in the state. As a teacher, I have frequently asked what were the expectations for my students that did not speak English or were very new to speaking English. Sadly, the answer was always the same. Oh, they'll get it. This never sat well with me because for my English-speaking students, they were frequently tested and planning was very purposeful around what they didn't know and what they should know by a certain point. For my English learners, at some schools, there were some supports, and at other schools, the only supports were what I provided with the assistance of Google Translate and any volunteers or friends that I could get to help me create bilingual documents and learning aids. At parent-teacher conferences, parents of my English learners were grateful for any assistance I was providing, but they never asked me the important questions I'm sure they had. They never asked me, how much support is my child receiving during school in English? Is my child receiving equal support when they take tests in English that they may not fully understand? Or what does English support look like for my child during the school day? Or do you think my child is missing out on any important opportunities because my child does not speak English like their peers? Parents often rely on schools to make the best choices for their children. They often feel nervous, scared, or inadequate asking questions to the people whose job it is to make sure their kids get the best education. AB 195 will establish some clear standards that are greatly needed for our English language learning students and support to their families. Data is very important to collect, and it will allow us to know the type of resources that are needed to help our educators provide support for the English learners in their schools. More resources are needed, but they vary from school to school, and with sufficient data, appropriate planning can be made to ensure a more equal educational context for these children. The English Learners Bill of Rights will ensure that students have access to all services that our schools provide, and will ensure that parents understand the placement and development of their children in programs for English learners. I strongly implore each of you to pass this bill to make sure a large population of our students no longer falls by the wayside, but is ensured equal access and equal rights to quality education in our state. Along with this testimony, our educators have submitted additional testimony located in the exhibit section on that list. I respectfully ask all of our members on this committee to review that testimony. Thank you.
Thank you. Any other callers in support?
To testify in support on AB 195, please press star 9 now to take your place in the queue.
Para
testificar en apoyo de la ley AB 195, por favor presione estrella 9 ahora para tomar su lugar en la fila.
Caller with the last 3 digits of 520, please clearly state and spell your name for the record. You will have 2 minutes and may begin.
Llamador con el número 520, es su turno y tendrá 2 minutos para hacer su apoyo.
Chair Bilberry, Axelrod, Vice Chair Miller, members of the Committee on Education, my name is Anthony Ruiz, ANTHONY RUIZ, representing Nevada State College. Nevada State College is in full support of AB 195 and want to thank Assemblywoman Selena Torres for bringing this bill forward. We certainly support this bill, which aims to better meet the needs of English language learners in the state. We also remain committed to expanding the teacher pipeline with qualified bilingual educators and look forward to working with the school board on this bill's tracking, data, and transparency measures. This bill is greatly needed in our state to ensure equitable practices, and we urge members to support this legislation. Thank you.
Sorry, apologize. Next caller in support.
Sorry, Chair. Caller with the last three digits of 284. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Persona con el número 284, es su turno. Tendrá 2 minutos. Indique su nombre completo y deletrelo.
Caller with the last three digits, 284. We cannot hear you. Is your phone on mute?
Persona con el 284. No.
I apologize. I was having technical difficulties. Good afternoon. My name is Yesenia Gonzalez, Yesenia Gonzales. Good afternoon, and I would like to thank the sponsors of this bill and the committee members for allowing me to share why it is of utmost importance that we have AB 195 passed in our community. I was once a former ELL student who personally went through the struggles many students and families faced in my school district, which is in Clark County, or was in Clark County. Unfortunately, due to the immense language barrier we face, our children have gone through receiving inadequate services, abuse that is not communicated to parents due to the fact that many families face being limited in English proficiency, parents not knowing their rights, especially when it comes to their children who receive special education, thus becoming a denial of parent participation as they cannot properly advocate for their children. Families do not know who they can turn to for help as they fear retaliation from school. Families also not also knowing they are entitled to having an interpreter accompanying them in a meeting at school. I grew up having parents that didn't know how to advocate for me as a special needs child with autism, therefore impeding me on having a quality education and services. My parents didn't know how to express or be able to address concerns that they had as interpreters as having interpreters in their native language were unavailable or hard to come by. My parents didn't know when I was being praised by a teacher, or at times interpretation fell on me, which was extremely frustrating and stressful as I struggled to find the correct words to say as I was learning just as they were trying to. As an advocate who once trained with a special education attorney, I saw how many mothers had no idea if their children were meeting their goals or what their present levels were, what their children scored on tests, and the meaning behind them. I faced schools that would become frustrated as I interpreted to the mothers that I volunteered to help with what was being said because they couldn't understand what I was translating to the parents. Now, can you imagine and now understand the same frustrations that countless families face in my community? Every child deserves a quality education, and that every parent has the opportunity to support their child every step of the way. Thank you.
Thank you for the call. I understand that there's some people in the queue that are Spanish speakers who do not have their hands raised. I don't know, BPS, if you could explain how they raise their hands, and then Olivia could translate that.
I can have Cindy from Broadcast explain it in Spanish, if that is all right, Chair.
That's great. Thank you.
Y para testificar en apoyo de la ley AB 195, por favor, presione la estrella 9 ahora para tomar su lugar en la fila.
And I know we have a caller that was currently in the queue, so we'll go with that caller, and then hopefully we can get those other folks online. Go ahead, BPS.
Caller with the last three digits of 455. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Llamador con el número 455, es su momento, tiene 2 minutos, indique su nombre completo y tendrá 2 minutos.
Chair, Vice Chair, members of the committee, my name is Gil Lopez with the Charter School Association of Nevada. Here we are here in support of Assembly Bill 195. Growing up as a CCSD ESL student in Northtown, I can attest that access to information should lead to well-informed decisions. Thank you, Assemblywoman Torres, for this important bill, and we urge your support. Thank you, Chair.
Thank you for the call. Broadcast, were you able to, did hands go up?
We saw some hands, but we'll make sure to check it again.
Sí, para testificar en apoyo de la ley AB 195, por favor presione estrella 9 ahora para tomar su lugar en la fila.
Caller with the last 3 digits of 886. Please fully state and spell your name for the record. You will have 2 minutes and may begin.
Llamador por
Thank you, Chair.
886, indique su nombre completo y tendrá 2 minutos.
Thank you, Chairwoman and member of the committee. My name is Vida Lin, Vidalin, and I'm the founder and president of the Asian Community Development Council. ACDC is a product of a long-term dream of mine. I moved to Nevada to help my extended family to navigate the public school system. My nephew needed academic accommodation, but due to the cultural differences around schooling and a language barrier, it was difficult for my family to access necessary resources. While helping my family advocate for my nephew for CCSD, I saw that there are very few resources to help families to navigate the public education system. There are 300,000 limited proficient Nevadans who lack resources to help translate documents or critical information. 20 years after I moved to Las Vegas to be closer to my family to help them with accessing with public education for my nephew, I founded ACDC, which now provides in-language resources, youth development program, and college readiness boot camp, among other critical services to our community. This bill is a right step forward for our school system to catch up with the needs of the English language learners and their family, and to close the achievement gap. Thank you.
Thank you, BPS. Any other callers in support?
Caller with the last 3 digits of 018. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Llamador con 018, indique su nombre completo y tendrá 2 minutos para dar su testimonio.
Good afternoon. My name is Jim Sullivan, Jim-Sullivan, and I'm here today representing the Culinary Union. The Culinary Union supports AB 195 because it is an important step towards improving outcomes for English language learners and protecting the rights of students and parents. As the largest organization of immigrants, Black, AAPI, and Latinx workers, the Culinary Union represents 60,000 working families in Nevada. Culinary Union members come from 178 different countries and speak more than 40 different languages. AB 195 would ensure that our schools are meeting the needs of all of these students. As the largest organization of parents in Nevada, the Culinary Union believes that having a robust English language learners program is critical to the future of our state and a necessary component of a just education system. The Culinary Union urges you to support and pass AB 195. Thank you.
Thank you for the call. Next caller in support.
With the last 3 digits of 023, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Persona con 023, indique su nombre completo y deletrelo y tendrá 2 minutos.
My name is Brenda Pearson, BrendaPearson. I'm reading into the record a statement by Anna Ocasio-McAndrew. Hello, Chairwoman Bilbray Axelrod and committee members. I am a learning strategist at Fremont Professional Development Middle School, and I have been a CCSD employee for 27 years. I am writing to you as a strong appeal that you support AB 195 for English language learners. I have been a strong advocate for these students throughout my entire career because I am also one of them. I can empathize with the inadequacies and lack of support from the educational system. I was an English language learner when there were no programs. It was sink or swim. Fortunately, I was able to swim and survive to continue with my quest to help those who need it most, the children. They depend on adults for their expertise so that they too can endure and swim. The time is urgent. With the upcoming influx of newcomers expected to arrive at our doors, now more than ever, we need to provide for these students. If we are to welcome them with open arms, we must be prepared to demonstrate that they are important. The enforcement of AB 195 will guarantee equal access to high-quality programs and transparency to their parents and legal guardians as an integral part of the solution. Ultimately, the establishment of comprehensive data collection and reporting requirements will aid with their triumphs. This information will be most beneficial to guide those responsible and help direct them with the implementation of adequate programs and resources. I humbly ask you to support AB 195 for English language learners, to give them the resources they need and help them become productive, viable citizens that we can all be proud of. Please aid them by providing the necessary tools. Give them the chance to be educated and become tremendous assets of our great nation. Thank you.
Thank you for the call. Next caller in support.
Caller with the last three digits of 437, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Llamador con 437, indique su nombre completo y deletrelo y tendrá 2 minutos.
Good afternoon, and thank you to Madam Chair and to the members of the committee. My name is Augusta Massey. Massey is spelled Massey, and I am the president of the Las Vegas chapter of the National Bar Association, the oldest and largest association of African American attorneys, lawyers, and jurists in the country. The LVMBA is testifying in support of AB 195 today. As the president, as an immigrant, as a lawyer, and as a mother, we sincerely support this bill. We believe that Nevada is stronger when all groups thrive, and currently those at the bottom, which are special education students and English language learners, are performing and losing out due to COVID-19. The ELL Bill of Rights is the right solution for these times. Parents need to become better advocates for their students so that they can receive the instruction and the services that they need, and only then will all of us in our state be able to grow and become part of a productive workforce. I believe as immigrants and as citizens, we all want the same thing, which is quality education, good schools, and the ability to raise decent human beings. So we thank you for the opportunity to speak in support of this bill. Thank you.
Thank you for the call. Next caller in support.
Caller with the last three digits of 883, please press *6 now to unmute.
Llamador con 883, por favor presione estrella 6 para quitarlo de mute.
Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Indique su nombre completo y deletrelo y tendrá 2 minutos. Puede iniciar.
Thank you. My name is Myra Salinas Manjivar, spelled Mayrasalinas -MENJIVAR, and I'm here to express my support for AB 195 as a former ELL student in Clark County. First, thank you, Chair Bilbray Axelrod, for bringing this important bill for a hearing, and thank you to Assemblywoman Torres for carrying the bill. As an immigrant child who grew up in Clark County and a product of the Clark County School District, I can personally say that this bill is necessary to promote the advancement of students in Nevada. They are the future of our state, and this bill ensures that our future is bright. Our ELL population is not adequately informed of their existing rights. Many parents are not provided information in a language that they can understand in order for them to adequately be informed of the rights of their children. The ELL program has long been a program that parents do not know what it involves,
And usually all they know is simply the title of the program, but not what services it provides or what services it entails. That means they do not have the information necessary for them to adequately advocate for their children and to ensure their children are receiving what they need to be successful in school. But this bill does not only address the rights of immigrant children like myself. These rights belong to all children raised in non-English first language households. For example, my nephew, whose first language is not English, he is a U.S. citizen born in Nevada, and he too has a right to ELL services. Being bilingual is a quality that makes children more likely to be successful in school, but they need the support necessary in order to do so. For myself, I went through public schooling in Clark County, went to college, and I'm now an attorney in our community. AB 185 ensures that the families of ELL students now know their children's rights so that they can hold the school districts accountable for providing those services to their children. I urge the committee members to vote in favor of this bill. Thank you.
Thank you for the call. Next caller in support.
Caller with the last 3 digits of 448. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Llamador con
Hello,
448. Go ahead.
Hello. My
ahead.
name is Valeria Gurr. Can you hear me?
Yes.
Dear members of the committee, thank you so much for your time. My name is Valeria Gurr, VALERIAGURR, and I'm the Nevada State Director for the Nevada School Choice Coalition, and I work with hundreds of low-income families. I'm here to share my support for AB 195. It is extremely important to have data on ELL students, and I would prefer to say emerging bilinguals, so the legislators at the school board can take and have informed decisions and implement programs that will really support their learning. Research shows that parental engagement is key of success on the life of a child, and if parents have more information about their children and how they're performing in the schools, we will be able to help them. They will be able to help their children at home. I have seen firsthand how language is a barrier for bilingual parents when it comes for helping their children or accessing information. However, these parents are, if they would have more information, they would be doing a wonderful job at their home with their children, because I know that parents care about the education of their children. Also working with, particularly with Latino and Hispanic families, I have learned that in many cases parents don't understand their rights. And if they see something that they don't agree with their students, or if they're not at level, they just don't say anything because they fear of retaliation or legal status and language barriers. Instead of speaking up, they simply leave the school. And I also have learned in some of the cases that if anything happens in the school and the students are not being helped, also the person that might be doing something wrong in that school stays there unaccountable, and that's not good for the other students. So I'm really in support of this bill. There's a lot of other families that are proof of why this is important, even in this process. I brought a bunch of different families from CCSD that would like to speak in Spanish today, and they are having a hard time understanding the system. Thank you so much for my testimony, for listening to my testimony today.
Thank you very much. And I think we have Spanish speakers coming up. I think we've managed to work it out. So fingers crossed.
All right.
Next caller.
Caller with the last 3 digits of 591. Please press *6 to unmute.
Por favor, llamador con 591, presione estrella 6 para quitarlo de mute.
Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Indique su nombre completo y deletrelo y puede iniciar.
Ok. ¿Necesito un traductor?
Yo soy la traductora. Hable lento y yo le voy a traducir.
Está bien, gracias. Estimados miembros del Comité de Educación, mi nombre es Luz del Carmen. Mi nombre es Luz Cota. Se deletrea para su récord LUZCARMENTORES. C-O-T-A.
Ok, permíteme
Vengo
traducir.
hoy a-
Permíteme traducir. My name is Luz del Carmen Cota, L-U-Z-C-A-R-M-E-N-C-O-T-A. Continúa.
Vengo hoy a apoyar la ley AB 195.
Ok, permíteme. I come here today to support Bill AB 195. Continúa.
Soy madre de 2 niños que asisten al CCSD.
Okay, I am a mother of 2 children who attend CCSD. Continúa.
Mi hija cuando llegó a su escuela desde México acá, tuvo un tiempo muy difícil porque a ella le costaba comunicarse con sus compañeros y maestros.
Okay, permíteme. When my daughter arrived here from Mexico, she had a difficult time communicating with teachers and with her school peers. Continúa.
Y me hubiese gustado que ella hubiese tenido más apoyo y yo saber cómo ayudarla.
I would have liked for her to have had more support and for me to have known how I could have helped her. Continúa.
Ahora ella está en el grado 11 y ya se comunica mejor.
Now she is in 11th grade and now she communicates better. Continúa.
Sin embargo, mi hija me cuenta que el sistema educativo aún está muy retrasado.
However, my daughter tells me that the educational system is still behind in how to best teach. Continúa.
En cuanto a enseñarles a poder escribir y redactar mejor.
In terms of how to write and compose better. Continúa.
Tener más información de la que se les enseña a nuestros niños nos ayudaría a nosotros como padres.
Having more information about how our children are taught and how to help us as parents. Continúa.
A también poder dar más recomendaciones.
And also to help us to give more recommendations.
Muchas gracias.
Continúa. Thank you very much.
Es todo. Muchas gracias.
That's all. Thank you very much.
Muchas gracias. Next caller in support.
Siguiente llamador en apoyo.
Caller with the last 3 digits of 008, please press *6 to unmute.
Llamador con 008, presione 6 para quitarlo de mute.
Caller with the last 3 digits, 008. You will have 2 minutes. Please slowly state and spell the name for your record, and you may begin.
Llamador con 008, indique su nombre completo de letrero, tendrá 2 minutos, puede iniciar.
Mi nombre es Yoconda Silva. Se deletrea G.
Continúa.
G-I-O-C-O-N-D-A-S-I-L-V-A.
Okay, permíteme. My name is Yoconda Silva, G-I-O-C-O-N-D-A-S-I-L-V-A. Continúa.
Les hablo hoy para apoyar la ley AB 195.
I am here to support the Bill AB 195. Continúa.
Soy madre de 2 niños que asisten a escuelas públicas.
I'm a mother of 2 children that attend public school. Continúa.
El proceso de poder entender cómo mi hijo iba progresando fue muy frustrante.
The process of understanding how my son was progressing was very frustrating. Continúa.
Porque no tenía la información o ayuda para saber dónde acudir para hacer consultas sobre el estado o progreso educacional de mi hijo.
I did not have information or help to be able to know where to go to consult over the progress of my son in his educational process.
Siento que
Continúa.
si hubiese tenido más información, la ayuda para el proceso de aprendizaje de mi hijo hubiese sido más fácil para nosotros.
I feel that if I had had more information in the process of how to help my son in his learning process, it would have been easier for us. Continúa.
Es por eso que AB 195 me parece una buena propuesta de ley.
That is why I feel that Bill AB 195 seems like a good idea as proposed law.
Para que podamos aportar mucho más a este país.
So we can support this country a lot more.
Muchas gracias.
Thank you very much.
Muchas gracias. Next caller in support, I think we have one more caller. Is that correct, BPS?
That is correct, Chair. Caller with the last three digits, 369, please press *6 to unmute.
Llamador con 369, presione 6 para quitarlo de mute.
You will have 2 minutes. Please slowly state and spell your name for the record, and you may begin.
Tendrá 2 minutos, indique su nombre completo para el acta y deletrelo y tendrá 2 minutos. Inicie.
Mi nombre es Diria Baeza.
My name is Diria Baeza.
Se deletrea D-I-R-I-A-B-A-E-Z-A.
Spelled D-I-R-I-A-B-A-E-Z-A.
Como todos sabemos, todos los niños tienen derecho a una educación.
As we all know, all children have a right to an education.
Para que se les permita desarrollarse como individuos y poder convivir en sociedad.
To be allowed to develop as an individual and be able to carry out in a society.
Una de mis hijas es de edad escolar.
One of my daughters is of school age.
Siendo español como su primera lengua.
Being Spanish as her first language.
Se le asignó una escuela donde no le daban la suficiente atención.
She was assigned to a school that she did not receive sufficient attention.
Ya que el inglés lo tenía como segunda lengua y los profesores no podían ayudarla.
Given that English was her second language and her teachers were not able to help her.
Mi hija sufrió mucho en esta escuela y pasó por una gran depresión.
My daughter suffered much at that school and she went on to suffer depression.
Por la falta de ayuda que nos proporcionó el sistema escolar.
Because of the lack of help the school system offered it.
Por eso estoy a favor de AB 195.
This is why I am in favor of Bill AB 195.
Ya que los padres latinos tenemos como prioridad la educación y el crecimiento emocional de nuestros niños.
Because Latin parents as a priority have the education of their children and their emotional well-being.
Por ello pido se nos entregue los recursos necesarios.
This is why I ask that we are given the necessary resources
para poder apoyarlos desde nuestro hogar.
To be able to support them from our homes as well.
That's all. Thank you so much.
Thank you so much.
Muchas gracias. And I did want the committee to know and the public, we had 41 minutes of support. So I will allow 41 minutes of opposition if that is there. So we will move on to opposition testimony. And I just want to thank committee members for, I know this is it's been a long day thus far. So thanks for sticking it out. And for those who are waiting on the phone, I promise we will get to you. So let's move on to opposition testimony.
To testify in opposition on Assembly Bill 195, please press star 9 now to take your place in the queue.
Para indicar oposición, oprima el estrella 9 para oponerse a este proyecto de ley AB 195.
And I apologize. We have not had any indication of Spanish speakers.
Oh, okay. All right.
But thank you, Olivia.
Caller with the last two digits of 859, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good afternoon. My name is Janine Hansen. I'm the state president of Nevada Families for Freedom. We oppose AB 195. NBC News reported COVID-19 began battering families, putting parents out of work, shrouding their homes with grief and loss, shutting children out of schools that taught and cared for them. It's taken an unthinkable toll on children, social, emotional, and academic. From the Associated Press, we read the report cards of the school year are arriving with more F's than usual, in a dismal sign of the struggles students are experiencing with distance learning. School districts from coast to coast have reported the number of students failing classes has risen by as many as 2 or 3 times. In this devastating situation for our children, AB 195 is inappropriate. We are giving special rights to students and their parents who are likely here in our country illegally. At this critical time, we should be concentrating on our own citizens' needs. My own granddaughter from Washoe County is failing because she has had such a difficult time with online learning. In addition, AB 195 contains an unfunded mandate, forcing local school districts and taxpayers to pay for the myriad of mandates contained in this bill. School districts are already strapped, and many taxpayers who have lost their jobs and businesses have hit bottom. We now have an extreme crisis at the border, bringing more illegal aliens into our nation and state. We already have programs for English learners. How much more will taxpayers be forced to pay, and how much more will school districts be burdened, leaving our own citizens without the necessary help they need to succeed in school? We oppose special rights for children and their parents who are here illegally. Thank you.
Next caller in opposition.
For those callers who have just joined, to testify in opposition on AB 195, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 105, please slowly state and spell your name for the record. You have 2 minutes and may begin.
This is Lynn Chapman, State Treasurer of the Independent American Party, LYNNCHAPMAN. The federal law mandates that all states will educate all the children. What issue in this bill issues in this bill are already covered in the federal law that our state are already following? I'm concerned with the unfunded mandate. That's a biggie. Somebody has to pay for all of this. The Education Commission of the states back in 2014 did a state profile on Nevada, and it stated that in 2014-15, the state allocated $24.95 million for ELL services. Our questions are how much is needed for the unfunded mandate? How much more? How much more money is being spent in Nevada for ELL programs now as opposed to what it was in 2014, and how much more is needed with the unfunded mandate? How much money is being spent per ELL pupils over and above the per pupil spending that our state provides? These are some of the issues that we're really very concerned with. And we're trying to look out for the families of this state, and they're already hurting financially. I have a friend who is retired and told me a couple of days ago that if the property taxes go up anymore, she's going to lose her house. This is not the way we should be treating Nevada citizens. The taxpayers are already taxed out, and with as much money as ESL or the ELL program is receiving, perhaps you can take care of all of this without expecting the taxpayers to fund any more. Please oppose AB 195. Thank you.
Next caller in opposition.
To testify in opposition on Assembly Bill 195, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 917, please press star 6 to unmute. Please slowly state and spell your name for the record. You will have 2 minutes and may begin. Caller with the last 3 digits, 917, we can't hear you. Is it possible your phone is on mute?
My name is Susan Rue, spelled SUSANRUCH for the record. I'm calling in opposition of Bill AB 195. Federal law already mandates the state that they must educate all children, whether they are here legally or not. AB 195 is an unfunded mandate to start with, so the states will not be paying for this, but the school districts will be, meaning that the taxpayers will be paying. Do you think it will be wise to ask the taxpayers if they want the additional burden on their school systems? These children will be receiving a free education regardless of their immigration status or primary language. Schools must supply an interpreter in all meetings with the guardian or parent in their primary language. Realistically, we are going to have a huge influx of children coming from the southern border because they are already here. If they are being registered by a legal guardian, most likely their parents are not here, which means they could possibly have come across the border with a coyote or a human smuggler. If this is the case, they're going to need additional psychological counseling because they're traumatized children. My heart goes out to these children as they are pawns in a perverse political system. All of this puts huge financial burdens on the school systems, which are already having problems. The big question is, what about the American children? They have not been in school for a year, and now their education is being diminished by children who are here illegally. Our country is a country of laws, and we have borders. Parents who have other options are leaving the schools in droves. We should be using the funds to help our children of the U.S. who have lost a year of education or more. Therefore, I strongly oppose AB 195. Thank you.
Thank you. Next caller in opposition.
To testify in opposition on AB 195, please press star 9 now to take your place in the queue. For those callers who just joined, to testify in opposition on AB 195, please press star 9 now to take your place in the queue. Chair, at this time, the line is open and working, but there are no more callers to testify in opposition on Assembly Bill 195.
Thank you. With that, I will close opposition testimony and open it for neutral testimony. I believe actually we have someone on the Zoom who would like to testify in neutral. Did you want to go ahead and do that, Department of Education? Department of Education, were you coming in as neutral or were you going to call in? Perhaps that was the way you're how we typically do it. Okay, we'll go ahead to the phone lines, and if you guys figure out the Zoom, we'll come back to you. Go ahead to the phone lines, BPS.
Thank you, Chair. Caller with the last 3 digits of 936. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good afternoon, Chair Bilbray Axelrod and members of the Assembly Committee on Education. This is Sarah Nick, SarahNick, on behalf of the Nevada Department of Education. The department is testifying in neutral and would like to clarify that the WIDA exam used in Nevada to assess the proficiency of English learners is already a criterion referenced exam as well as the SBAC. The department thanks the Assemblywoman for bringing forward AB 195 to support Nevada's families of English learners, and we would like to work with the Assemblywoman on an update amendment to AB 195, as we are testifying in neutral to the current amendment introduced today and the inclusion of a criterion referenced assessment for the literacy of pupils enrolled in elementary school. Thank you, Chair.
Thank you for the call. Any other callers in the neutral position?
To testify in the neutral position on AB 195, please press *9 now to take your place in the queue. Once again, to testify in neutral on AB 195, please press *9 now to take your place in the queue. Chair, at this time, the line is open and working. There are no more callers to testify in the neutral position on AB 195.
Thank you, Broadcast Services. I appreciate your hard work as always, and thank you to our translator, Olivia Buford, as well.
You're welcome.
Appreciate your hard work.
Thank you.
Muchas gracias.
De nada.
Assemblywoman Torres, did you want to make any closing remarks?
Yeah, I think that there might have been somebody who had been in the chat.
Pardon me? Are you?
I think Assemblywoman Marzola is going to make a comment. I don't know if you want to go to her first.
Oh,
like
I did not see that. I apologize. Assemblywoman Marzola, did you have a comment to make? Or question?
I do. And if I can just make a quick comment, please, Chair.
Sure. Go ahead. I'm sorry I missed that.
Oh, no, no problem at all. I just wanted to make a statement. I'm an immigrant. I'm originally from Brazil. I came to this country with not knowing one word of English. So I was an ELL student. I'm not sure if such a program was in place when I came here. It definitely was not at my school. So nobody knew what to do with me once I was registered. I'm 10 years old and I was put into kindergarten to try to communicate and learn the English language, which let me tell you, it's a really hard language to learn. You know, the pressure of a child coming to another country, not knowing anything, not knowing the language, it's really tough. Let's remember that it doesn't matter where you come from, what your language is. What's important is that we encourage these children, is that we empower them, is that we give them tools to succeed. You never know who they're going to be. They can be your next teacher. They can be your next attorney, doctor, assembly person, right? Let's give these children the tools necessary. Let's not discriminate, because whether you like it or not, these kids are our future and we have to invest in them, because investing in them means we're investing in Nevada. Thank you, Chair.
Thank you, Assemblywoman, and we're glad you came here when you were 10 and happy to have you as a part of this body. Assemblywoman Torres.
Thank you, Chair. Assemblywoman Selena Torres, for the record, I want to begin by thanking the Chair for her commitment to ensuring that we had a fair hearing today, and commitment to ensuring that all Nevadans could participate not too often that we have translators come into our hearings to ensure that members of our public can participate in the hearings, and that's exactly what we did today. And I really commend you for taking the time and and the staff here at LCB for ensuring that we could get a translator on today's call so that every Nevadan that was eager to participate in our call today could. I want to make it abundantly clear that this bill does not propose special rights for our English language learners. Rather, it enumerates the rights that our English language learners and their families have. And I believe it's very important for these families to understand that they have the right to a free and public education, regardless of their immigration status, every single day. And if getting a copy of their rights or having those rights posted online will help families and members of our community that you heard from today feel more comfortable engaging in our schools, then I think this is a piece of legislation worth having. The opposition today argued that students are struggling in response to COVID-19, and for whatever reason, this legislation was going to take away from other students that are struggling with COVID-19. And as an educator who taught throughout the entirety of this pandemic, I can say that a piece of legislation like this will help empower the ELL students in our community and their families that continue to sit in our class. Throughout summer school, I had students that were engaging with digital technology that did not have a computer prior to the pandemic. And we were talking and collaborating in Spanish. And it was because of the relationship that I had with that student's family that we could build that relationship and have that communication. But had that student and had that family not felt comfortable, they would not have had that interaction, that engagement, that conversation with myself, and would not have had access to any education throughout the pandemic. And so I think a piece of legislation like this will provide opportunities for Nevada families and Nevada students. I'm committed to working with the stakeholders, and I do want to note that several individuals noted that there was a fiscal note for the counties, and that's just simply not true. I spoke with the counties earlier today. The fiscal note has been removed from local counties. I do understand that there has been a small fiscal note from the Nevada Department of Education for less than, I think it's less than $15,000, quite honestly. And, you know, I do want to remind the committee, and I know we're not a money committee, but with the Recovery Act funds that are coming in right now, over $115,000 will be designated to the Nevada Department of Education for translation services. And I definitely think that a piece of legislation like this would help align with the vision of the Recovery Act, if so desired. So I really appreciate the committee for their time today and ensuring that we get a fair hearing on this piece of legislation. And additionally, I know several individuals have reached out to me, Assemblywoman Claire Thomas, Assemblywoman Michelle Gorlo, Assemblywoman Elaine Marzola, to be added as co-sponsors to this legislation. I look forward to adding them on. Thank you.
Thank you, Assemblywoman. And once again, thank you to our broadcast services and everyone who helped out in this tough time that we're dealing with, having a fair and committees that people are involved in. So with that, I will close the hearing on AB 195, and I will move to our last item, which is public comment. As a reminder, you have 2 minutes of public comment, and this is not to discuss the bill that we have heard. It's just to general matters that fall within the purview of our committee. So BPS, do we have any callers who would like to speak in public comment?
If you wish to speak in public comment, please press star 9 now to take your place in the queue. Once again, if you wish to give public comment, please press star 9 now to take your place in the queue. Chair, the line is open and working. However, we have no callers for public comment at this time.
Thank you, BPS. Are there any comments from members before we adjourn? Now look, I'm not seeing any. Okay, the next meeting will be Thursday, March 25th at 1:30. We do have a packed agenda and probably will for the next few weeks at least. So bring a snack if you need one. This concludes our meeting for today, and meeting is adjourned.